available a few days after the presentation. Becky Roberts and Lynn Markham are your presenters today. Becky and I are both land use specialists. Becky, you may begin the presentation.
All right, thank you, Lynn, and thank you all for joining. It looks like many of you have already found that initial poll that has popped up on your screen. What we're asking for there is just simply to share what is your role. Typically, we find most people are serving in local government, but what specifically is your role, and also how many are attending from your site. So it looks like the majority of you have already responded to that. So I'm going to end the poll and share results. So the vast majority, I shouldn't say the vast majority, but the largest percentage of those participating are planning and zoning staff, roughly 1/3 of participants. About a quarter of you are plan commission members. We also have about 18% that are clerks, administrators, and then we have a handful of elected officials, zoning board of adjustment or appeals members, and other members joining us. It looks like most of you are joining individually, but there are a few groups here as well. So thank you all for joining us, and we're going to go ahead and get started. I'm going to share those poll results. You may need to minimize that on your screen in order to see the full slides. So just use that little X out button. All right, so a few key takeaways for the day. We're going to be talking about zoning and the purposes and functions of zoning. We're also going to talk about specific zoning decisions. So permitted and conditional uses, rezones, variances, and administrative appeals. And throughout this, we'll also be weaving in the role of local officials. Okay. So why do we have zoning? I oftentimes leave this question blank and have participants answer this in the chat function, or if we're doing a live program. One of the most common answers that I hear is to separate incompatible uses. And that's certainly been a major function of zoning. Traditional Euclidean zoning is heavily based on uses, but communities have been moving beyond that. So I want to share some other reasons that communities have zoning. Fundamentally, if we look back 100+ years to when communities first started innovating with zoning, and then it was tested through the court system, the justification, the purpose for zoning was upheld as protecting public health, safety, and welfare. We've also continued to evolve zoning, and so it's gained additional purposes over time. Natural resource protection can be a very strong goal for zoning, especially when we're thinking about specialized forms of zoning, such as shoreline zoning, wetland, floodplain regulations, and so forth. We can also utilize zoning to look at community character and certain levels of aesthetics. And then certainly there's also finding this balance between protecting public and private investments. Okay. So we do have one more poll early in this presentation. Lynn, I'll let you pull that one up. But I want to get a sense in terms of who's joining us. We have a sense of what your positions are. This is going to tell us a little bit more about your level of government and who's actually administering zoning within your community. So there's really three different options here.
I'm not available. I'm not able to launch the poll.
Okay, I can get it launched then. So there's really three different options here. Let's see, I think I need to stop sharing this. I'm going to talk through this for a moment.
Launch it.
Oops. All right, it looks like it popped up. Is everyone seeing that? Yes, and I'm seeing people answering this. Okay, so who administers zoning? There's really three different options here. County zoning, where the county and towns work collaboratively to administer zoning. Second option would be municipal zoning, where a city, a village, or a town directly administers zoning. And then the third option is no zoning, and there are certainly examples of this within Wisconsin. So let me show you a little status map as you're completing this question. So this shows these three different options. You can see geographically the largest land area within the state falls under county zoning. So we have about 60% of towns that participate with their counties in under county zoning. Okay. The second option, municipal zoning, we have about 20% of towns that administer their own general zoning ordinance. And I do want to say this is distinct from shoreline zoning. Oftentimes a county will administer shoreline zoning. And then in addition, either the county or the town can administer general zoning. In the case of general zoning, it's one or the other. You can't have both county and town's general zoning, right? About 75% of villages and almost every single city within the state administers municipal zoning. And then that third option, kind of seen in some of these light gray areas, is no zoning. About 20% of towns, 25% of villages, and only 4 cities in the state have no zoning. So let's go ahead and share the results of the poll. It looks like for most of you joining us today, 74% have a municipal form of zoning. So where the city, village, or town has adopted the local ordinance. About a quarter of you have county zoning, and only 1 participant has no zoning. So I'm curious which community that is. It sounds like you may be interested in zoning, and you're welcome to reach out to us after this webinar should you need assistance or additional resources on that topic. So I'm going to stop sharing, and you may need to X out of that poll to get it off of your screen. Okay. So I alluded to some special forms of zoning. Sometimes these can be standalone ordinances. That is often the case with a shoreland or wetland zoning ordinance or a floodplain zoning ordinance. And sometimes you can have additional protections that act like an overlay district. And again, these could be in a separate ordinance, or they could be described directly within a general zoning ordinance as well. So the image that's shown here is some of these setbacks. It's almost like an overlay beyond a lake or a river where shoreland, wetland, and floodplain zoning would apply. That same concept could be utilized to protect municipal wells, so through wellhead protection districts, bluff or steep slopes. You may have specialized forms of farmland preservation zoning, airport protection areas, and extraterritorial zoning is certainly an option within the state as well. Just to make sure everyone's on the page, I'm going to go through a few slides here talking about fundamental or basics of zoning before we get into specific decisions. So when we think about a zoning ordinance, an ordinance is really divided into 2 different components. If you are a visual person who likes to look at maps like I do, oftentimes that's the first place that you go, is the zoning ordinance map. The map shown on the screen here really divides a community into different zoning districts. So you may have a series of different commercial districts, you may have different residential districts, industrial, a variety of conservancy or natural resource type protection districts, and so forth, okay? Then you also want to look at the text of the ordinance. The text describes regulations, and these regulations can either apply community-wide, or they may be specific to one of these given districts that is mapped. So as we look through the organization of an ordinance, these are the typical components that you will oftentimes find within a general zoning ordinance. So we have purpose statements, zoning districts, allowed uses, dimensional and development standards, and administrative procedures. Let me just take you through visually what this can look like. So first we have purpose statements. And as Lynn will discuss when she gets to conditional uses, purpose statements have actually grown in importance within the state. These purpose statements provide justification for having the ordinance in the first place, as well as justification for why we're regulating different areas in different ways, or perhaps why we are regulating things as conditional uses. Okay, this really helps remind elected and appointed officials, zoning staff, and courts why the regulations exist, and also how to interpret and apply the regulations. So it's important if you're doing an ordinance review or update that you actually think a little bit critically about this. You may find these at the beginning of your ordinance. You may also find purpose statements associated with specific districts. And oftentimes we're now seeing communities include specific purpose statements associated with conditional uses as well. So another pretty much universal element of most zoning ordinances would be the idea of these zoning districts. I have some images here. What I want to say about this is that there's not one universal set of zoning districts. Okay, this varies from community to community. You often see similar nomenclature, such as this R1, R2, R3, and so forth. That's really just indicating different intensities for residential zoning districts. You can see the same type of setup for commercial districts and industrial, mixed use, and so forth. Okay, so oftentimes when I travel around the state and I'm looking at different zoning ordinances, depending upon who created that ordinance, perhaps you had assistance from a local consultant, from a regional planning commission, maybe you based your ordinance heavily on the counties. There's oftentimes similarities, but know that you do have the ability locally within every single zoning district, within every single community to craft these districts to best fit your community and to name them appropriately as well. Then for any given district, we also have allowed uses. And typically we think about permitted, conditional, and sometimes prohibited uses. What you see here is a fairly prescriptive and detailed list of uses for a given zoning district. What we're finding within the state and what I actually advise is that it's pretty difficult to describe every single possible use under the sun, right? So a lot of communities are moving towards use-based classification systems and also towards use tables where they're organizing and describing what uses are allowed within different districts. We do have an example of a use table as we move into Lynn's section. And if you're interested in some of these more modern techniques for presenting uses and describing them, I'm happy to share some resources. We've done a webinar on refreshing your zoning ordinance where we talked a little bit about that. Okay. Then we have dimensional standards. And again, this is typically specific to each district, but this is where we might be describing density, lot sizes, can include both minimum and maximum lot sizes, setbacks from property lines, from the front, side yards, rear yards, or perhaps from a resource such as a shoreland area. Some communities include lot coverage standards, so you can only have so much impervious surface, or you need a certain ratio of open space. And then you may also have height limitations. Again, that's very important in an airport district, for example. Okay. And then we also have development standards. Development standards are one of those things that oftentimes applies community-wide or to a range of uses. So for example, in a commercial district or across commercial districts, you might have the standards for stormwater management, parking, landscaping, signage, lighting, and so forth. And then lastly, we have an administrative procedures section. This describes who does what. So who's responsible for granting each of these permits? What are the timelines that you need to comply with? What's the process? So just to summarize, if you are new to zoning and you want to walk away with some terminology, the important decisions, these are the 5 terms that I recommend you familiarize yourself with. Permitted and conditional uses, which Lynn is going to describe in just a moment. Rezones and zoning amendments, which I'll pop back on to discuss in just a bit. And then lastly, Lynn's going to wrap up talking about variances and administrative appeals. So with that, Lynn, I will hand this back to you.
Sure. Thanks, Becky. So for each zoning district, we have 3 categories of land uses within the zoning ordinance. We have those permitted uses, which you'll see are represented by green, and the colors along the bottom kind of correspond to a stoplight. Green, go, yellow, maybe, red, stop. So green, the permitted uses are allowed by right in all parts of the zoning district. Conditional uses are those in yellow. That use needs to be listed for the district and is allowed if it meets the ordinance standards and any conditions placed upon it. The prohibited uses are those uses that are not listed in the ordinance or uses that are listed as specifically prohibited. So those are the 3 types of uses. Here's an example of permitted, conditional, and prohibited uses in a residential district. And like Becky noted, every zoning ordinance can be different, so it may be different in your ordinance. But in a residential district, typically we see permitted uses for 1, 2, 5 unit dwellings. Conditional uses could include small businesses such as bed and breakfast and corner stores, as well as playgrounds, schools. And then prohibited uses in a residential district are usually those uses with higher impacts, whether it's large stores or storage, or whether it's industrial uses that might have emissions that wouldn't be ideal in a residential district. This is the table that Becky was referring to, showing across the top the zoning district, A1, A2, rural residential, and then down the bottom, different land uses. Some land uses are permitted. You can see the livestock facility is permitted under A1. It's a conditional use under A2, and it's not allowed in the residential districts and commercial districts. So this is just a nice way to show in your zoning ordinance where different uses are allowed, in which zoning districts they're allowed. Okay, now we're going to jump into conditional uses. For those of you that are new to this, the conditional use law did change in 2017. It's different than it used to be, at least the way some communities administered it. So the definition that was provided at that time is conditional uses mean those uses allowed under a conditional use permit or a special exception. Those two terms are almost interchangeable, or any other zoning permission, special zoning permission. But conditional uses do not include variances. They're separate, and we'll talk about them later on. The process for conditional uses. For all conditional uses, you need to have a Class 2 notice and a public hearing. If they're decided by the zoning board, they will be appealed to circuit court. The ordinance may also specify alternate routes. So if it says that conditional uses will be decided by the Plan Commission, then they're typically appealed to the zoning board. If conditional uses are assigned by the ordinance to the governing body, such as the county board or common council, then those conditional use decisions are appealed to circuit court. So this is our next poll. In your community, which body has the final authority to decide conditional uses? Is it the Plan Commission, the governing body, or the zoning board? State law says it can be any of these three. So we're just checking to see how you handle it in your community. In the meantime, we'll talk a little bit about conditional uses. So these are some of the basic standards. Like I mentioned earlier, it has to be listed in the ordinance for that district. In addition, you need measurable criteria for judging an application for a conditional use. Conditional uses can be granted or denied based on the applicant's ability to meet the ordinance standards that are listed for that conditional use. The body deciding them can attach reasonable conditions. Those conditions have to be related to the ordinance purpose, but can be conditions that are separate than the standards listed in the ordinance. The conditions can limit permit duration, how long the permit is good for, transfer, or renewal. The local government and the applicant, when deciding on conditional uses, both have to provide substantial evidence supporting their decisions. So that means substantial evidence on the part of the local government body for why a condition is necessary. And it means substantial evidence on the applicant's side showing how they will meet the standards in the ordinance and any conditions. And then state law says if the applicant meets or agrees to meet all the requirements and conditions, the local government must grant the conditional use. So this is what I mean in terms of there's less flexibility than there used to be. If something's listed as a conditional use in your ordinance and the applicant shows that they will meet all the standards, then the conditional use has to be granted. Okay, so now looking at who decides that conditional use, it looks like in most communities, it's the governing body that is making the decision. In about a third of the communities, it's the Zoning Board of Adjustment or Board of Appeals. And in a smaller fraction, it's the Plan Commission. Now, one thing to keep in mind, even though the Plan Commission looks small here, it's possible that in the communities where the decision is made by the governing body, it's possible that a recommendation comes from the Plan Commission to the governing body before it's decided. But a good sign that you know who's deciding conditional uses in your community.
Lynn, I'm just gonna pop in here and go back to the last slide. The
Sure.
length of these bars is actually based on a survey that we had put out a number of years ago in terms of who has final authority to decide conditional uses. So a little bit different than what we saw in the results of those attending today. In many communities, it's actually the Plan Commission who has that final authority, followed by the governing body and zoning board. And I don't know if that's been changing over time. This was collected maybe 5 years ago. But just wanted to share that point as well. So I'll go ahead and advance.
Yeah. So maybe we'll figure out why you're unusual. Okay, so what does substantial evidence mean? I use that term on the last slide, and it's defined in statutes as facts and information. So it's not personal preferences, it's not opinions, it's not speculation, it's not third person through the grapevine information. It needs to be facts and information that directly pertain to the requirements and conditions that the applicant has to meet. Also, that reasonable persons would accept in support of a conclusion. So if it goes up to the judge, if a conditional use is appealed, it's not saying that the judge, him or herself, would make the same decision, but that a reasonable person, given this evidence, would come to the same conclusion. So let's think about when a conditional use comes in, what is the role of the governing body or the Plan Commission or the zoning board? First, if you look at that upper right-hand corner, this is a quasi-judicial decision. So you're acting like a judge, and we'll talk a little bit more about that under variances. But because you're acting like a judge when deciding on conditional use decisions, you'll be reviewing the proposal compared to the ordinance criteria for that conditional use, determining the credibility of the information presented by the applicant and during the hearing, and then determining if you'll grant or deny the conditional use using that substantial evidence test, relying on facts and information. It's not an opinion poll. You want to make sure that the conditions imposed are reasonable and measurable, and that they relate to the ordinance purpose, and that the local governing body or the decision maker from the local government has substantial evidence for why those conditions are needed. You also want to create an adequate record of your decision to provide support in case the decision is appealed. And that's a point that's common to conditional uses and variances. You want to make sure that the evidence is in the record so that when the judge looks at it, they understand the reasons that you granted or denied the permit. This is just an example of specific standards. This is from the Stevens Point zoning ordinance, looking at accessory dwelling units that are allowed by conditional use. Some communities allow accessory dwelling units by permitted use, but in the Stevens Point ordinance, it's allowed by conditional use in these zoning districts that are listed. Some of their standards are 1 ADU per lot, not more than one. There's a height limit of 20 feet, a setback of 10 feet from other structures, a maximum impervious surface coverage of 60%, and the owner needs to be on site the majority of the year, needs to live on site. Also separate utility connections. So these are a list of the standards for conditional use in one ordinance. All right, I also want to touch a bit on staff reports. Staff reports can be very valuable, looking at what are the facts that were provided by the applicant when they submitted their application, ensuring that it is a complete application, that they've addressed all the standards in the ordinance. So putting that together, what are the facts? What's the analysis of whether the criteria in the ordinance are met or not met? And then providing recommendations to the local government body that will be deciding on conditional uses.
Great. Well, I'll take this back over and talk just a little bit about rezones and zoning amendments. So I talked about the two elements of zoning, which are the text and the map. And similarly, we can make changes to either the text or map over time. Typically, if we are thinking about change to district regulations, such as allowed uses, setbacks, or something that applies community-wide, we typically call that a zoning ordinance amendment. In the case of map amendments, we can also make changes that apply community-wide. We typically call those map amendments. But when we're thinking about changing the district boundaries for one given property, another term that communities will use is typically a rezoning. Okay, all of these, whether it's something that affects the community as a whole or an individual property, are considered legislative decisions within Wisconsin. That means local decision makers actually have quite a bit of discretion. So these decisions to change zoning must be reasonable and constitutional. We also require in Wisconsin that changes to zoning ordinances and certain other ordinances be consistent with a comprehensive plan. And then there's some communities that have chosen to go a little bit above and beyond this and give specific rezoning standards within their zoning ordinance. I'll give you an example of that. So again, think about this. Just imagine, let's say you were the governing body or plan commission providing a recommendation on a rezone. Sometimes it's a bit challenging if you're just presented with this open-ended decision. So these are the types of criteria that communities may place in front of local decision makers as recommended criteria, or they could directly adopt something like this within a zoning ordinance. So here's some examples, reminding folks that the amendment needs to be consistent with the comprehensive plan. Reminding people that the amendment or the change will not be detrimental to the property, either in the immediate vicinity or to the community as a whole. No adverse impacts on the ability to provide adequate public facilities or services, or on the natural environment. So you could think about factors like air, water, noise, stormwater, soils, wildlife, vegetation, etc. Okay, and in some cases, you can actually mitigate some of these adverse impacts. So you can think about mitigating that by improvements on the site or some slight adjustments to the proposal. Okay, so how do we go about determining consistency between your zoning ordinance and your comprehensive plan? Okay, the first place that most people look is to the future land use map. So you're looking for guidance in terms of what uses are allowed. Okay, then we're oftentimes double checking with the text of the comprehensive plan. Within the text, you may describe what are those future land use categories, what densities are allowed, what uses are allowed, and so forth. And then you're determining if the proposal is consistent with the plan. Okay, certainly, if it appears consistent with the map, with what you're describing is occurring on that map, then you can absolutely recommend approval. If it's not consistent or you have some questions, you have two different options here. One, you could recommend denial if it's blatantly not consistent. The other option you actually have is you can amend the comprehensive plan prior to adopting that ordinance change or that rezoning. Okay, so you do need to amend the comprehensive plan first and follow the process for both the plan amendment as well as the ordinance amendment. So different communities have different views here. Some communities like to say, we've adopted this plan, it's guiding us 20 years into the future, and this map specifically is good for 10 years, and we're going to make very little changes to it. But certainly there's other communities who are making some pretty regular changes to their planning documents, and they're also getting proposals that they may not have expected. And so if they're finding value in what's being proposed, there are some communities that are going back and changing their plan to allow for additional uses and rezoning opportunities. One thing I want to point out here, coming down the pipeline, there's there's at least a half a dozen different housing related bills that have been first introduced in the assembly. There's one in particular that's going to make some pretty drastic changes to comprehensive planning and to rezoning decisions, particularly related to residential development. So I want to point that out. They're out of the gate. They've been making their way around the track, but they've not quite hit the final approval stage. But I do believe that these are going to be approved. So if you're interested, and I will drop a link to this in the chat, I would encourage you to look at Assembly Bill 453 and Senate Bill 472. There's been some changes that have been proposed, but it's still making its way through the approval process. So having said that, let me just give you some of our best guidance at this point, recognizing that some of this could change with these changes to comprehensive plans and zoning requirements. So this first example that I have here is showing a future land use map for the village of Mount Horeb. And what I'm going to do is first I'm going to zoom into the left side of this map, kind of the upper left hand portion, and then I'll zoom into the upper right hand portion and discuss what we see here. Okay, so this is the edge of the village of Mount Horeb, and this is an area in which they intend to grow. It's actually outside of their municipal boundary, so they're cooperating with the neighboring town to think about future land uses as well as zoning for this area. So let's say you got a rezoning proposal for this area. Okay, there's a few different things that we can look at here. First, there's this underlying color on the map. And in this particular case, the community did something unique. And you can see there's this color wheel. They said that a planned development within this area could actually include a variety of different uses. So things ranging from sewered, single-family residential, two-family, multifamily. It could include government and institutional, mixed use, and parks and recreation. So they're pretty wide open in terms of potential future land uses within this area. But you can see, and this is a little bit of an unusual technique. I like it for presentation purposes because it's very straightforward. They did include an annotation directly on this map. And in a nutshell, what they're saying is development of this area is conditioned on the improvement of a new north-south collector road. Okay, so think about that from the perspective. If you are a local official or perhaps a staff member administering zoning, if you got a rezoning for this area, let's say this is an existing agricultural area and someone's proposing, a new mixed use residential area with, portion of commercial and portion of residential. What are the questions you're going to be asking? Okay. My first thought is this consistent in terms of use? Yes, you may have some additional requirements in terms of density and other requirements. But the other thing I'm seeing here is this condition under which growth can occur. Okay, so the first thing I would be asking as a staff person or a local official is, do we have that appropriate road capacity to allow for this? Okay, and if not, might we consider looking to, let's say we have a capital improvement plan or road construction plan that extends out for the next 3 to 5 years. You'd be looking there to see, is this something that's proposed or planned and budgeted for? And so you can go down that path and keep questioning, if it's not planned for and it's not budgeted for, is the developer able to contribute to this project? And if not, that's where you finally get to that decision point. Well, maybe this area is not appropriate for additional development density at this point in time. So this might be a situation where if you can't meet these conditions, you could deny that rezoning. Let me give you one other example, and this is from, again, the same community, and here they have a different development constraint. Here they say development of this area is constrained by utility capacity. Okay, so they're limiting new density within this area or gross density to 2.25 dwelling units per acre. Okay, and then they say unless alternative utility arrangements are made. So again, that's really great guidance to say, we anticipate future development here, but we need to make sure we have the infrastructure and we've addressed resource constraints. Okay, not everyone, and I'd say the majority of people are not going to be including specific text on the map, but this is really helpful for illustrating some of these points about what you could include within the text of the ordinance. One other way we can think about this, some communities are developing these, what I call a consistency matrix, and this is just a little snippet. The way this is organized down the left side of the screen, you see these future land use categories that would be associated with the future land use map found within the comprehensive plan. So we have commercial areas, downtown areas, office research. If you were to continue on, there's different residential areas as well. Okay, and then there's guidance provided. Okay, so there's a general description of what types of land uses are allowed. couple of things I'll highlight here. In this case, the community is also giving guidance on what are appropriate zoning districts for implementing this. Oftentimes, the plan is more generic or more general than the zoning ordinance itself. So in a given commercial area, there might be a variety of zoning districts that could be used to implement this. Here in this case, their preferred zoning district would be their B2 general business district. But there could also be a highway business district, a planned unit development, and so forth. Okay. Here they've referred to the density and lot size requirements in their zoning district, but that's something that you could also potentially spell out within a plan. And that's actually one of the criteria that those proposed Senate and Assembly bills are asking for, is they're asking for communities to give additional guidance, at least in residential districts, on preferred density. Okay. And then the last thing I want to highlight here are these development policies. And this is kind of like the text annotation we just saw from the village of Mount Horeb directly on their map. Here in this case, the one I'm circling is timing rezoning to when public sanitary sewer and water services are available, and a specific development proposal is offered. Okay, in this case, you don't necessarily have to, just because you're planning that a future area could be appropriate for changed uses or additional density, you don't actually have to rezone those areas until the point in time in which development is proposed, and you can see that specific proposal. All right, one more example. I had just shared more municipal examples. Here's an example from a town. So this is the town of Black Wolf, which is located in Winnebago County. This is a fairly recently updated future land use map. I think this was just completed earlier this year. And I want to show how they've created their future land use categories. They essentially have 3 different categories that are based on density. So you can see this is like Winnebago. Okay, and then they also have a sanitary district. So you can see the little slashes here, which has extended throughout portions of the more developed areas along the lakefront. Okay, and that often corresponds with some of their higher density planning areas. So in the case of this high density parcel area, it's either within or completely surrounded by their sewer service area. And they're suggesting that this is suitable for more intense development, higher density, but smaller lots. And they include a 1/2 acre minimum parcel size. Okay, so that was kind of this greenish, yellowish area. Next, kind of this middle ring, that's a little bit more of a brown color, are medium density parcels. That's immediately adjacent to that sewer service area. And they view this as a transitional zone between the higher and lower density areas with a 1 acre minimum parcel size. And then lastly, this light brown tan area, those are low density parcels, which are completely outside of, not adjacent to the sewer service area. The intent here is to remain rural and to have limited development, to retain open space, agricultural uses, environmental protection. So what they've done here is they actually have a 4 acre minimum parcel size. And at the same time, they also have a maximum density, which is 1 parcel per 10 acres. And the intent there is that they don't have a scattering of 4 acre lots throughout this area, but they're limiting the overall development, rural development within those areas. All right, so Lynn, I will go ahead and hand this back to you to discuss variances now. And I do also want to remind folks, if you have questions as we're presenting here, we do have some time reserved at the end. So feel free to start throwing some of those questions in the chat box and we'll get to those real soon.
Thanks, Becky. I was going to remind them of the same thing.
Perfect.
Okay, so now we're gonna dig into variances. Variances are assigned by state statutes to the zoning board. The zoning board of appeals or zoning board of adjustment always decides on variances. So the zoning board functions like a court. The justice shown on the right-hand side with the blindfold and the scales is often used to represent, a judge, someone making that decision. The reason they're wearing a blindfold is because it's not to be based on the applicant. It's not whether the judge likes or doesn't like somebody. It should be independent of the applicant. And then the scales are to weigh the evidence. So like conditional uses, it's not based on whether this is popular or not, a given variance. It's based on whether the applicant meets the legal standards. So zoning boards are required to follow current laws, and I'll touch on exactly which laws in the future, but certainly it includes state law as well as their local ordinance. Zoning boards apply these laws to particular fact situations in order to make these quasi-judicial decisions. So when a person applies for a variance, then they apply the variance standards to that particular situation. And a zoning board has to apply the laws as written. They're not allowed to change the laws as they might want to. Their job is to apply the laws, just like it's the job of a judge to apply the laws as they're currently written. A variance allows a property owner to do something that's prohibited by the zoning ordinance. Variances are meant to provide relief in limited, rare circumstances. They're not meant to provide general ordinance flexibility. To provide flexibility, that's done by changing the ordinance so it applies equally to everyone, not to specific people like a variance does. We have two types of variances in Wisconsin. The first is the most common type of variance, an area or dimensional standard. So that applies to dimensional criteria, physical, dimensional, locational. So these are your setbacks, your frontage widths, your lot sizes, heights, bulk or density. So that's our typical type of variance. There are also defined by state law use variances. These allow a landowner to put a property to an otherwise prohibited use. Use variances are prohibited in shoreline zoning, and a zoning ordinance can, and we have a number of zoning ordinances that do, simply state no use variances. An example of a use variance would be if you have a residential zoning district and someone says, I want to place a racetrack right in the middle. If you allow use variances, then the zoning board in one meeting could approve the racetrack through a use variance. Okay, the main standards for variances, the legal standards are, it's the applicant for the variance that has the burden of proof to show that they meet these three tests that come from state statutes. First, they have to have unnecessary hardship, that it would be a hardship to live on this property without the variance. And we contrast that. The courts have contrasted unnecessary hardship, it's a hardship, versus personal convenience. Personal convenience is the deck or whatever addition a property owner might want. And the unnecessary hardship has to be based on conditions unique to the property. So the size of the property, the width of the property, if there are wetlands on the property, steep slopes on the property that prevent building, those would be conditions unique to the property. Things like how many children someone has or how many cars they want to fit in a garage or a shed do not fit for a variance because those aren't conditions unique to the property. They're unique to the property owner, which is different. And then the third standard is a variance cannot be contrary to the public interest. The public interest is the purpose and intent statement at the beginning of the ordinance, like Becky was talking about earlier. So if you grant a variance, it can't, for instance, reduce public safety, or if it's in a shoreland area, it can't harm the fisheries. So that's going to those purpose statements to see if a variance would impact them negatively or not, if it would be contrary. And there's one other piece on this slide, and that is floodplain variances. The three standards shown here apply for all variances: general zoning variances, shoreline variances, floodplain variances. But if it is a floodplain variance, if someone is asking to build in the floodplain in a way that's not allowed by the ordinance, then the applicant needs to show that they meet an additional 13 standards that apply just to floodplain. And if you do have floodplain variances come before you, I can get you the floodplain variance application and decision form so you can see what those standards are. All right, why do variance decisions matter? If we think of the purposes of a zoning ordinance being the water that's in a bucket, if variances are granted that don't actually meet the legal standards, but just people would like to do X, Y, or Z, it's like poking holes in the bucket and you lose the purposes of the ordinance. And I have a couple examples of that. Under general zoning, we know that our purposes usually include health, safety, and welfare. The photo shown below is two rural roads that each have a speed limit of 55 miles an hour. If you come up from the bottom left, there's a stop sign about where you see the tree line where the intersection is. However, a home was built that did not comply with the roadway setbacks. And so when you come up to that stop sign, to that intersection, and look left, you can't see if anyone's coming because of that structure there. This is a intersection I went through regularly as a high school student on my way to the high school. And a few years after I graduated, there was a news article saying that a teenager had died at this intersection because he did what many of us did and pulled into the road in order to see around the house and see if someone was coming. So this is an example of granting variances that don't meet the standards can impact the purposes of the ordinance. For roadway setbacks, that includes safety. And then the second example is floodplain zoning. Floodplain zoning has different purposes than general zoning. In this case, you're trying to protect human life, not have people get hurt during a flood, protect health because mold can be a real issue after flooding, and minimize property damages and economic losses. You know, nobody wants to lose a home or a business. So granting variances and allowing buildings to be built in certain areas of the floodplain reduces those protections to human life, including the emergency service folks who go out to rescue people during a flood. And it can increase economic losses. If you have any questions about floodplains, feel free to reach out. Okay, so overall, the zoning board functions like a court. Here are the 4 types of law that need to be followed: the state statutes, the local ordinances. Zoning boards can also have their own set of zoning board bylaws, and then case law. These are the court decisions, Supreme Court decisions and Court of Appeals decisions that are published, set legal precedent, and have to be followed by zoning boards. And that's why we do zoning board workshops, to stay up to date on case law. A solid legal record also minimizes legal costs, having attorneys represent the zoning board in court and having decisions sent back to the zoning board. We'll talk a tad about appeals. This is how zoning decisions go through the appeal process. You can see if a governing body makes a decision, it goes straight to circuit court. That's where it's appealed. Whereas plan commission and zoning administrator decisions typically first go to the zoning board of appeals or adjustment, and then up to circuit court, Court of Appeals, and Wisconsin Supreme Court. What standards do those courts use? Courts defer to local decision makers when these tests are met. So this is essentially how to make a legally defensible decision as a local government so that the courts are likely to uphold it. You have to have the legal authority by statute or ordinance to act on the matter. You have to follow the proper procedures, which include open meetings law and public notice. Follow the proper standards. We just talked about the 3 standards for a variance. For conditional uses, your standards are found in your local ordinance, and you need to follow those standards when making your decision. The rational basis is, were the decision makers unbiased? Could a reasonable person reach the same conclusion given the evidence? And the last test is, the evidence needs to be in the record so that it goes up to the courts. A few recommended resources. On our website, you'll find workshops, webinars, as well as handbooks for Zoning Board and Plan Commission. And this is where you will find the webinar recording and the resources that go with today's. We've already posted Introduction to the Plan Commission, the webinar and resources, and from the Zoning Board. And a few days after today's webinar, we will post that as well. And then secondly, we have an online training resource. And so this is the content of the webinars, perhaps a bit more detail that you can go through on your own time. We have one segment that's for Plan Commission, one that's for Zoning Board. So this is another option to go through to get up to speed on these topics and learn new approaches. And with that, thank you for attending, and we'd be happy to respond to questions. I can see we have one, maybe a couple.
We have one
And
question, which is for me, Lynn, so I'll go ahead and jump right in.
Okay.
So the first question was, can rezoning approval be contingent upon requiring an applicant or owner developing a collector town road? Can that be a condition of approval? So I know this relates to my section on zoning ordinance amendments and rezones, and specifically, you were probably thinking of the Village of Mount Horeb example that I gave, where I walked you through having that collector road in place before development is allowed. I would say you can't go this far, okay? You can use that as a basis where you are overburdening public facilities, or you have a real concern about not being able to support a development. You can use that as a basis to say no, but you can't use that as a basis to say, we require that you build this infrastructure as a condition of rezoning. A developer could certainly offer to do that. They're very motivated to make those conditions right to allow for that development, but I don't think you can require that. You can use that as a factor in your decision making, however.
Okay, and I see another question that came up, and it's about variances, so I'll take that one. It says a homeowner would like to build an addition on their home. The home was built before zoning and does not meet the setback from the center line of a town road by a couple of feet. The homeowner would like to build the addition toward the said town road, which is not highly traveled. Could they get a variance? Okay, so I'm not familiar with this exact situation, but like we just talked about with the photo of roads and setbacks, one of the purposes for roadway setbacks is public safety, to keep structures back a certain distance from the road. And that's so that you have the visibility, that people see a car or something who may be backing out of a garage or who may be coming, past that home or garage. So one of the questions to ask is, would allowing this variance reduce public safety, one of the purposes of your ordinance? And then another reason for roadway setbacks is to allow space for utilities that might have to go down the side of the road, including ditches to carry stormwater, and also to allow for road widening in the future. If you have homes built right up to the edge, you have less room, obviously, to widen the road if that's necessary. And then there are the other two standards for a variance. So one is unnecessary hardship. So is it truly a hardship to not have this and to not have an addition? And is it based on unique property limitations, the property itself, not the property owner? So those would be the standards to consider in terms of whether to grant or deny that variance. Are there other questions out there?
As
Oh, I
Lynn
see
was
Becky.
speaking, I was just posting a link to that pending legislation. This is called Assembly Bill 453 and Senate Bill 472. So when I look on the legislative website, the status is that it's available for scheduling. So it's been approved through the Assembly and has passed mostly through the Senate. I do also want to add on that particular one, there's going to be a delayed effective date of January 1, 2028. So you will essentially have 2 years to kind of process and think through that, those potential changes. So there will be more educational opportunities coming in the future. So don't get too concerned just yet, but put that on your radar. Right, we'll give you just a few more moments. I'm seeing a thank you already in the chat box, but if you have any additional questions, feel free to post them. You are also welcome to reach out to us individually. You can see displayed on the screen here. Email addresses are the best way to reach us. We don't always have the capacity to respond immediately the first day, but we'll try to prioritize and get to you as soon as we are able. And we did mention a variety of resources throughout the webinar that we can send to you in some instances. The recording of this presentation and the PowerPoint itself will also be posted on that webinar recording page. And you are more than welcome, and we certainly encourage you to share that with fellow Plan Commission members, zoning board members, staff, and so forth. So share it with your community widely if you can. We do have a few moments if you have any additional questions. If not, you're welcome to enjoy the rest of your day. All right, so I haven't seen any additional questions shared, so I'm going to go ahead and stop the recording, and thank you all for attending. I appreciate it.
Thanks for joining us.